Welcome to the latest First Amendment Salon. At the outset, I'd like to thank all of the fine folks at Ballard Spar for making these salons possible. We very much appreciate it. I am particularly pleased to introduce our two participants today, Floyd Abrams and Paul Clement. He is popularly known as Mr. First Amendment. No other lawyer in the United States is more closely associated with freedom of speech and freedom of press than Floyd Abrams. His work at the Supreme Court traces back nearly a half century to the time he filed a brief on behalf of the National Broadcasters Association in Miami Herald Publishing versus Tornello. Add to that the many times this senior counsel at Cahill Gordon and Reindel has testified before Congress, the countless newspaper articles he's written, the numerous scholarly articles he's authored, and the 3 books he has published on the First Amendment. And of course, there's the Floyd Abrams Institute for Freedom of Expression at Yale Law School. In light of all of the above, it is no wonder that a documentary is currently in the works to chart out the incredible arc of the life and work of Mr. First Amendment. Floyd, welcome.
Thank you.
It is also my pleasure to introduce someone who might well be tagged Mr. Supreme Court, both as a former Solicitor General of the United States and thereafter as a litigator in private practice. Paul Clement has argued over 100 cases in the Supreme Court. Before he became a partner at Kirkland Ellis, his knowledge of the workings of the court was informed by his clerkship for Justice Antonin Scalia. In many ways, Paul is a lawyer's lawyer, and then some, as indicated by the fact that just this last term, he won 2 cases in the Supreme Court, plus a cert grant in another case to be argued next term. One final point. Paul has argued more First Amendment free expression cases before the Roberts Court than any other lawyer. Paul, welcome to this evening's salon.
Thanks, it's great to be here.
With that, gentlemen, the salon is yours.
Well then, okay, I'll start it out. Welcome, Paul. It's so good to have this chance to chat with you and even ask you a few questions as we go along.
It's my pleasure.
I guess I wanted to start, since this is a First Amendment salon, to ask you on the broadest level if you agree with a phrase which has often been used about the Roberts Court and the First Amendment, and the phrase has been that it is the most protective court in American history of the First Amendment. What is your sense as to the degree to which this court has been involved in and has defended what were argued to be First Amendment rights?
So, Floyd, it's great to be with you, and it's a great question to sort of kick it off with. I think that, my way of thinking about this is I think there's a lot of truth in that aphorism or description of the Roberts Court as being the most pro-First Amendment court, in history. I think if there's a caveat, I think the caveat is that this court is, very uniformly left, right, and center pro-First Amendment, as long as the justices are kind of processing a case as what I would describe as a pure First Amendment case. The government as the regulator of speech, trying to prohibit a particular class of speech or the rest. I think if there's a way in which you might say that this court is not as pro-First Amendment as potentially some prior courts, at least on particular issues, it's really what I think of as kind of like the threshold level of whether what you have is a pure kind of free speech case or whether you have something else that makes it less of a free speech case or a pure free speech case, and maybe causes a majority of the justices to look at the case as kind of something else. And just to give kind of two examples, but I think there are others. This court, in the one breath, it can be very protective of free speech when it's thinking about the government as the regulator of speech or the censor. But if it's thinking about the government's own speech and the government as speaker, and you can get the court to kind of process the case as a government speech case, then sometimes the party that thinks they're vindicating the First Amendment ends up on the losing side, because it seems like there's a working majority of this court to say that when the government speaks, it's relatively unfettered. And so that's one way in which this court may not be quite as protective of free speech. Another that fits in sort of the same pattern is, if you can convince the court that this isn't the government as regulator, this is the government as employer. So we're in the sort of Pickering box instead of the kind of government regulating speech box. Then I think there's sort of a working majority of this court that's skeptical of those Pickering claims and a little bit more skeptical of protecting the First Amendment in that particular context. And so, and this will be something maybe I return to just in describing one of the court's cases this term. But I kind of think as an advocate before this court, a lot of the challenge is, if you're trying to vindicate the First Amendment, you want to work hard to characterize the case as kind of a pure or core First Amendment case. And if you, as I was in a number of the cases that kind of Ron was alluding to, if you're the government's lawyer and you're trying to defend something as consistent with First Amendment, if you have a chance of succeeding, it's going to be in convincing people that, no, this isn't sort of a pure core free speech case. This fits in some other box where the court may be less protective of the speech at issue.
Paul, I think the only case in the court that we were against each other, but I know in that case we were, in the McConnell Federal Election Commission case. I had to look back at the oral argument of the case. We were brilliant. But I was sort of struck by the fact that, as lawyers do, I went first. My side had lost below. I represented Senator McConnell, and I started out with the first line saying that what was at issue here was something that the court again and again in First Amendment cases has said was inadmissible, violative of the First Amendment. And you started by saying Congress had to deal with a problem. And the problem was one which required, and certainly would pass muster to do what Congress had done. And we do that as counsel all the time in terms of how we approach cases like this. But I find very valuable your observation about what sort of approach has a better shot of getting the court to view it one's way. In that respect, since I mentioned opening, I'm struck by the new coronavirus court broadcast, the chief calling on other members of the court one by one. Have you argued in any of those?
Floyd, I have argued one. I argued one of the May cases.
Was it very different as an advocate, arguing in that, I'll use the word, so much more structured fashion?
It was different, and it was more structured, and it was not sort of the kind of wide open and robust exchange of ideas you typically get when you're arguing in the Supreme Court and you have 8 or 9 justices lobbing questions at you in kind of close rapid order. one obvious way that it was different is that typically when you're arguing a case in front of the Roberts Court in person, I sort of use my terms carefully. Usually you're getting questions from 8 justices, not 9, because Justice Thomas is notoriously reticent to ask questions at oral argument. And one, aspect of the sequential ordered approach that was fascinating for the counsel was that it really, gave Justice Thomas an opportunity to kind of ask questions. I mean, just to put this in concrete terms, the argument I had was my 102nd, and it was the first time Justice Thomas had asked me a question. And I think he was actually on the court for all 102 of the arguments. So, it really was a game changer in that respect. What really struck me, though, is that kind of the experience for the counsel and Justice Thomas was entirely consistent with what Justice Thomas has always said when he's explained or partially explained why he doesn't ask as many questions, because his typical response is, well, I like to let the lawyers talk, and my colleagues tend to ask the questions that I was going to ask anyways. And because the sequential ordering went in the order of seniority, Justice Thomas was right at the beginning of the pecking order. So no other justices had asked his questions. So he did ask questions, and I think every one of the main arguments. A number of his colleagues then referenced a prior question of Justice Thomas's in their later questions, which gives some evidence that, he wasn't just blowing smoke there. They really, are asking questions that covered some of the same territory. And then the other thing that was interesting is that, at least based on some empirical analysis that I read, even though it was very structured and all of the justices had essentially the same amount of time to ask their questions, Justice Thomas still, on average, gave the counsel more time to respond than the other justices. So it was, one thing that was different and interesting was Justice Thomas and his role. I will say, though, and maybe I shouldn't say this, but this is after all a First Amendment salon, so I'm not going to self-censor. This ordered way of doing things, I think, actually makes the advocate's job a little easier, because in a typical argument, you're going to have some justices that are hostile, some justices that are less hostile. And in the sequential format, they all tend to be almost artificially forced to ask questions of you. And then the justices that are most hostile only have a set amount of time to ask you questions. And I wouldn't be so candid, because it wouldn't be true to say that, I tried to run out the clock on any justice, because I didn't. But the idea that that you're going to sort of only have 3 minutes of questions from a particular justice, and they're not going to be able to jump back in when you give an answer later in your argument. I mean, it is empowering for the advocate. It does sort of change a dynamic which in its pure form is stacked almost entirely in the court's favor. They can ask anything they want whenever they want. Counsel are strictly admonished not to interrupt justices, and it's not vice versa. And you go to that wide open forum where I think the advocate is at a little bit of an institutional disadvantage. You shift to something more structured, and it does candidly make the advocate's job a little easier.
From the opposite direction, but with the same conclusion, I think that one of the main things one sees, receives, gets as advocate in the court is that most, or at least a good many questions are designed to persuade the other members of the court, members that might not agree with them, or to show that the lawyer can't defend some proposition which the justice doesn't find persuasive. And so from their point of view, the converse of what you were saying a moment ago, they're losing their time. They're losing their ability to I mean, on the worst level, to mock us, but to score points. Don't you think?
No, I do. And look, if you look at Supreme Court arguments, over time, most of the questions the advocates get are hostile questions. I mean, you tend, not to get a lot of softballs at the Supreme Court. And, and frankly, if you get a bunch of softballs, it's maybe a sign you're not doing such a great job. And the justices that are inclined to support you think you need, a little bit of help. One of the most, profound things I've ever heard about Supreme Court argument was something my mother said after she watched my first Supreme Court argument. And, afterwards, like any good son, I was anxious to see what she thought about how I did. So I said, Mom, what did you think? And she said, well, I thought you were getting beat up pretty bad until the other guy got up. And, it does sort of capture the reality that you're mostly on the defensive. You're mostly getting kind of, hostile questions that, as you say, Floyd, are designed by a justice that maybe doesn't agree with you to expose the weaknesses in your case and expose them not just for their own benefit, but, maybe for the benefit of the justice that they think is the marginal justice in this particular case. And so when you kind of artificially truncate it, so, you might have 4 justices that are against you, 4 justices that are for you, and 1 that's kind of in the middle. If all of a sudden you go from an argument that's probably going to be 30 minutes of tough probing, mostly from the justices that disagree with you, to something where, it almost ends up being a little bit more like a Senate hearing. It's a lot more probing than that, don't get me wrong, but it's got the pattern of it where, you get beat up, but then you get somebody who maybe lobs you a couple of softballs, and then you get beat up again, and you kind of catch your breath. So it is a very different dynamic, and I do think it probably, on balance, makes the advocate's job a little easier and the justice's job a little harder, which makes me suspect.
One more structural question on the same theme. What was your reaction to the change in the court procedure, as it were, in allowing counsel to have 2 minutes of unobstructed advocacy before the justices start tearing you apart?
Yeah, that one. I mean, it probably at some level has the same format, which is, or the same sort of pluses and minuses. It probably does work to the advocate's advantage, and requires the justices to hold their fire for a couple of minutes. And when it was first introduced, a couple of the justices had a little bit of trouble holding off even for 2 minutes, which makes sense. But so I think on balance, I liked it because it did, it was a short enough period of time, but it did sort of give you the opportunity to kind of get something out that either framed the case in a way you liked or got some issues kind of off of the table. One thing is, I did a couple of arguments where I went first this term, and I think in each one I used the kind of 2 minutes slightly differently. I mean, in one of them, I kind of knew that there was a lurking kind of mootness problem that I probably would get lots of questions about. So I wanted to make sure that in the opening 2 minutes, I said a fair amount about the merits before I got sort of dragged down the mootness hole. In another case, I had kind of a menu of different ways that I could, my client could win the case. And so I wanted to kind of lay out the whole menu first, and then I could kind of refer back to it in the argument. So I thought in those different ways, it really helped to have the kind of 2 minutes to start with. So, I would say that I'm a fan of it. And we'll see. I think that's probably, my sense is that's probably here to stay.
Good. Why don't we turn to the First Amendment now? In the current term of the court had a number of First Amendment cases of interest. Why don't you, if you would, take the Thompson case first and just give us a sense of, so some of our viewers may not be familiar with it, but a sense of what it was about and your sense of the argument in it.
Sure. So, the Thompson case is one that might, sort of not get on everybody's radar screen, especially because, Supreme Court watchers, whether casual or very focused, tend to really focus almost exclusively on the cases that were on the merits docket or were granted for certiorari, and then they had oral argument. And, there is this kind of so-called shadow docket of cases where the court resolves them, and sometimes, resolves them in a meaningful and important way, but does so in a per curiam opinion without actually hearing kind of oral argument or without ever granting the cert petition. And so in the Thompson case, we were challenging the constitutionality of some of the campaign finance contribution limits in Alaska, on the grounds, not that, sort of all contribution limits are problematic, but on the more focused ground that the Alaska contribution limits were just too low to be constitutional. They might allow sort of bare association, but they didn't allow kind of meaningful association, is kind of the nature of the First Amendment argument we were making. Because Alaska has contribution limits that are basically $500 per election, and not just cycle, but for the whole election. So if you give $500 to somebody in the primary, you can't give them anything more in the general. So it's a very low $500 limit, and it was imposed, first back I think in the 70s, and then adjusted once, but it's generally speaking not adjusted for inflation. So this is something that we thought had a lot of the hallmarks of the campaign contribution limits in Vermont that were struck down in the Randall against Sorrell case like 10 years ago. And yet the Ninth Circuit, in its opinion, basically said that because there was no majority opinion in the Randall against Sorrell case, they were just going to kind of ignore Randall against Sorrell, and they were going to apply a much more sort of pro-regulation, anti-First Amendment standard of review. And so, we got involved in the case at that stage and tried to petition for certiorari. We were thinking that, this might be a useful opportunity for the court to grant the case, hear argument, decided on the merits, and come up with a majority opinion to replace the plurality opinion in Randall against Sorrell. But for whatever reason, and frankly, somewhat to our surprise, instead we got this per curiam opinion that vacated the Ninth Circuit opinion. I think it's fair to say chastised the Ninth Circuit for not applying Randall against Sorrell. My sense is, in arguing in the Supreme Court cares an awful lot about what they've said and not that much about what lower courts have said about the issue. And I think the corollary of that is they don't much like lower courts saying we're not going to pay any attention to what the Supreme Court has said, just because we couldn't get 5 justices on a single opinion. So, I think that the court was a little skeptical about what the Ninth Circuit did. I'd like to think that the court was a little bit skeptical about the Alaska regime as well, because it does look a lot like the Vermont regime, including the very low limits and no adjustment for inflation. So they sent it back, the way I read it, with kind of a hint that if the Ninth Circuit says that it's unconstitutional, maybe it won't be back. And if the Ninth Circuit just doubles down and says it's fine, we will be back in the Supreme Court, maybe on the merits the next time. So I don't think it's an earth-shattering decision, but I do think it suggests that there continues to be a working majority of the Supreme Court that is very skeptical of limits on campaign finance. That's obviously most true if it's a flavor of an expenditure limit, but I think this case shows that even contribution limits are not going to get a free pass from the current court. They sort of, we can debate exactly what form of scrutiny they're applying to them, but it's sure not rational basis for you.
Of course, the distinction in judicial treatment of contributions and expenditures comes from the Buckley case, and years afterwards, I was arguing a case, I forget which one, in which one of the justices sounded as if, in that case, he thought I was advocating something that they had said, and I was almost so tempted to say, "You did that." Don't put it on me. But what do you think? Do you think this court is of a mind at all to move away from the distinction between contributions and expenditures and treat them the same? I mean, it is difficult, this is my view anyway, to justify a flat distinction between one and the other. And certainly many people thought that that was a sort of compromise resolution reached by the court in Buckley versus Vallejo. But what's your sense about where they're going in this area?
So I'll give you my sense of where they're going, and I'll hedge a little bit by confessing I'm not positive exactly where they'll stop. I mean, I think where they're going is to kind of heighten, to sort of chip away at the dichotomy and heighten the level of scrutiny on contribution limits. And I do think, that the court has already said that it's going to apply some kind of, robust intermediate scrutiny to, at least that's the way I describe it, to contribution limits. So they're not going to get a free pass. I think something like the Alaska contribution limits, if they get to the Supreme Court on the merits, my bet would be they don't get approved but not because in that one case they just say, yeah, the dichotomy never made much sense, so we hereby get rid of it. I think what we're going to see is a chipping away, and all of a sudden the level of scrutiny of contribution limits is going to get kind of higher. And then where I have to hedge is, at a certain point, if you have 3 or 4 of these decisions where they strike down various contribution limits in ways that show that the scrutiny is more robust, could that end with the court ultimately kind of looking back at these patterns of decision and say, and in light of all of the caveats and all of the exceptions we've made and all of the rest, this really doesn't make any sense anymore, so we're going to scrap the whole thing? I think that's possible. Maybe I'd say that's not what I think is the most likely result, but I think it's possible. I think the thing I'm more confident about is, and this really says a lot about kind of what I think of the Chief Justice and his methodology as a justice. But I think it's a mistake to try to run to the Supreme Court right now and say, look, this dichotomy never made any sense. Buckley never made any sense. You got 5 people on the court that probably think that in their heart of hearts. So just scrap the whole edifice, stare decisis, be damned. I mean, I think that's a mistake. Whereas, if you're on the pro-First Amendment side of this, conversely, I do think the kind of more modest approach of kind of chipping away, and then maybe a few years from now saying, "Whoa, there's not much left." And obviously, you really saw that in the Citizens United kind of, and it sort of fits a pattern where and you see it in the Abood line of cases. I think the Chief Justice is much more comfortable at sort of chipping away at something where when he ultimately overrules something, it's like old news almost by the time he does it. I think that's much more in his comfort zone.
Let me turn to the Bar versus American Association of Political Consultants case. I'll take the lead and describing it. This is the case that arose out of Congress having adopted in 1991 the Telephone Consumer Protection Act, which bars just about all robocalls to cell phones. Just a sort of a national consensus. The public could not abide being called over and over again with recorded pleas to do this or do that. Some of them political and often not. And then in 2015, Congress amended it to put in an exception for robocalls to collect a debt owed to or guaranteed by the United States. So this is Congress saying no robocalls are allowed, but there's a reason. The government's entitled to collect its money, and the Congress is assisting the public, collecting the public fisc by saying it's time to say that in this area, in this particular area, robocalls are okay by or for the government. So the American Association of Political Consultants could care less about that amendment. What they care about is that they'd like to be able to do more robocalling about political matters. And they went to court and made a very traditional First Amendment argument that that what Congress had done was basically to treat as more important collecting the debt rather than political speech, and that couldn't be squared with the First Amendment, which is something that a very significant majority of the court agreed with. But what the American Association of Political Consultants wanted, and what divided the court more than who won the case about the exception, was to strike down the whole statute. And what they were saying to the court was, in this case, the act itself should fall, and that you ought not to sever the one more recent part of it, and you ought to take it as a whole, and taking it as a whole, make the decision that strict scrutiny applies. That is what 4 members of the court said. Or intermediate scrutiny applies, which is what 2 members of the court said. And the government can't meet it. And there was more argument on the court about what to do about the severability issue than there was at least about who won the case. But from the point of there was a severability section of the law, and the majority of the court wound up saying that they could sever out and should, in the normal course of events, sever out an unconstitutional element of the statute rather than letting it bring it down. But it's also a case, from my perspective, sort of teaching it as I do in Yale Law School class that I teach, that this is a case which shows most recently the enormous gap between what I'll call sort of the more conservative and more liberal members of the court in terms of how to approach First Amendment cases generally. Because this is a case in which there was deep division on the court whether to apply strict scrutiny and simply say, Congress has no business making distinctions based on content, no less, about this sort of speech rather than that, and therefore strict scrutiny ought to apply. Or what Justice Breyer and the more liberal members of the court were urging, which is saying basically we ought not to go down or continue down the road of saying that where there is a content distinction in a statute, that therefore strict scrutiny applies. And what Justice Breyer and his colleagues said basically is that this shouldn't be strict scrutiny, quote, because doing so is divorced from First Amendment values, and that what you're doing is giving too much protection to commercial speech, too much protection to regulatory speech. And that debate has been going on for years and years on the court. That the Sorrell case is one example, and to a considerable degree, they're arguing about something very much at the core of the First Amendment, sort of what's it all about? I mean, is it there to assure the government is not making decisions in this terribly significant area of law, or is it to assure that certain types of speech are fully protected in almost all cases from congressional or executive action? Because what the more liberal members of the court were signing on to there and have in a number of cases is moving away from applying strict scrutiny in cases in which what is not involved, in their view, is what the First Amendment is all about. Political, not just political, aesthetic, artistic, but not regulatory, not commercial speech. And on that, the court was 5-4, with the conservatives having 5 votes. Even though, as I said, there was very substantial agreement on the ultimate resolution of the case. It's a very interesting case, and probably, I would say, Justice Breyer's best presentation of an argument he's made on a number of occasions about how the First Amendment ought to be approached generally. That said, I want to come back to you and the very interesting USAID case. Could you tell us about that?
Sure, Floyd. No, that's great. I will. I'd say one more thing about the Barr case. I think you summarized it, wonderfully, and particularly, I'm very glad you kind of focused on the sort of the merits and Justice Breyer's approach. I just say one thing about kind of the severability argument. I kind of feel like, that's one where I'm not a big fan of the court's ultimate ruling on severability, because I think they kind of, and this was consistent with an argument I made in an amicus brief, but I think, severability is almost not the right word for it, because, they ended up taking out an exception, which had the effect of abridging even more speech than Congress wanted, which seems like a very odd remedy in a First Amendment case for the court to abridge more speech than even Congress did. And I think the reason there's that anomaly is because, it's at a certain point you start talking about the case as if the constitutional problem is with the government debt collection exception, and so that's what you should sever. But I really think that's the wrong way to think about it, because what's unconstitutional is a prohibition that includes the exception. But if that's what's unconstitutional, then the right answer should be to invalidate the prohibition, because that's what's abridging speech. And once you do that, it's not up to the court, or it shouldn't be up to the court, to sort of make the exception pop back. You should sort of leave the business of, maybe, abridging more or less speech back to Congress. But anyways, I thought that was very interesting. I think in another context, I think sort of the argument that, severability in the First Amendment context has to work a little differently, because it just doesn't seem consistent to me that, at some level you could describe the Barr case that the First Amendment challengers won on the merits, but the remedy was that the statute was rewritten to abridge more speech. And
you could certainly say that and the dissenters on this did, that the parties that brought the case were getting nothing. I mean, nothing at all, to which the response of the majority on this, that I thought was totally unpersuasive, was, well, yeah, they are getting something, because the exception, they're not being treated worse than other speakers. I'll tell you, the first time I saw the case, I wondered why there wasn't a more attractive argument to some members of the court that banning speech about political elections that happen to be in the form of robocalls a flat ban on that should have led some of the members of the court to be a little bit concerned on a more serious First Amendment level about the whole statute.
No, I think that's exactly right. And the one thing I just say that your comment really kind of crystallizes for me is that, you know, the majority's response to the dissent on the severability point is, as you say, well, they did get something, you know, they now get treated equally. And, you know, that might be a pretty decent response if this were an equal protection case. Because, you know, in equal protection, your constitutional entitlement is to be treated the same. And that's why there's a whole line of kind of equal protection cases that say that, you know, sometimes in an equal protection case, you can level up or level down. But that shouldn't be the way it works in a free speech case. I mean, when it's a free speech case, your beef is that the government is impermissibly abridging speech. The response to that can't be, you're right, we'll abridge more speech. But, you know, that's what this court case does. So I think it's an anomalous case. I think the court would hurt the challengers here and kind of cause the court to make what, in my view, is an error, is just, you know, is kind of the timing of this. You know, the prohibition had been on the books for like 20 years, and late in the game, this government debt exception was added. And so it seemed so easy to say, well, Congress was perfectly happy with the ban for, you know, 20 years. So if the problem is with the exception, let's just get rid of the exception. But I still think it was a mistake. But I think that's sort of the pathology of how the court got it wrong.
Yeah, I would add to that on a sort of realpolitik analysis of the case, I don't think they like robocalls any more than anyone else does. And you know, that they didn't have to swallow and leave it, you know, and get rid of it, the ban on it.
No, that is a reality that comes through in the majority opinion, and you know, something I'm wrestling with myself in terms of the kind of substantive case that the court's going to hear next term on the scope of the statute, which I'm involved in. So yeah, that's definitely a recurring issue. So let me just quickly talk about the other case that I think is worth talking about here. This is a case. It's USAID against the Alliance for Open Society International, and you know, that may sound familiar. And the reason it sounds familiar is the court sort of had an earlier version of this case a couple of years ago, and the basic prohibition in this particular statute is it basically says if you're going to get certain kinds of federal government funding for certain kinds of family planning and the like, you have to have a policy in place, or you can't have a policy in place that allows you to favor the advocacy of prostitution. So they basically say as a condition of the federal funding and receiving the federal funding, you know, and I just want to get the statutory language right, you have to have a policy. It limits the funding to those with a policy explicitly opposing prostitution and sex trafficking. That's the statutory language. So, you know, when the government limits funding to those that expressly have a particular government selected policy, that raises, you know, an obvious First Amendment problem. And so when the court had this case kind of on the merits in the context of the U.S. corporate entities that were receiving funding, the court, by a pretty lopsided margin, said, no, that's inconsistent with the First Amendment. The reason the case comes back is that a lot of the funding under this program was available for international purposes and international organizations, including separately organized corporate entities that were not incorporated as U.S. companies, but were wholly foreign companies. And so the question as it comes back up to the Supreme Court is, does the application of the statute to those foreign entities violate the First Amendment on the same theory that the court had already held that it violated the First Amendment when applied to domestic corporations? And the court holds, you know, essentially 5-4 that the application of the statute to the international organizations is constitutional on the grounds that the First Amendment simply doesn't apply extraterritoriality to these foreign corporations. And the opinion for the court that was written by Justice Kavanaugh, basically relies on essentially two propositions. One is that the Constitution, for the most part, is limited territorially to the United States, so doesn't generally extend extraterritoriality. There's some exceptions for particular provisions, particular circumstances, but as a general matter, the Constitution doesn't extend extraterritoriality and territoriality. And then he equally relies on the principle that of corporate separateness. And so his argument in the end is when you have a separately incorporated entity that's incorporated as a distinctly foreign entity, so the question is really, does the First Amendment apply to extraterritorially to that foreign entity? The answer for a majority of the court is that the First Amendment doesn't extend abroad, and it did split the court 5-4. The only thing I wanted to say about it is really, to me, this is a good illustration of the point I made earlier, which is, the way to win a First Amendment case, if you're the government in the Roberts Court, is not to kind of admit that the First Amendment fully applies and try to argue that you satisfy some relatively demanding level of scrutiny where the burden's on you. The route for the government to win these cases is at the threshold, make the case not a pure First Amendment case or make it about something else. And I think the story of the government's success here is they really made this case about something else. The question of to what extent does the Constitution, do the Bill of Rights apply extraterritorially? That's an issue that had split the court kind of on more traditional right-left axes before. And in a way that at least didn't surprise me that much, the government was able to get the 5 more conservative justices to say, essentially the Constitution and the First Amendment stop at the water's edge, and we're not going to apply the same principle to these foreign corporations.
This was the case because I found the dissenting opinion of Justice Breyer, and particularly some of the examples he gave, very powerful. He cited CNN. He says CNN abroad has to work through companies that are created abroad. CNN Mexico, CNN Taiwan, etc. He basically says it's almost, are you serious that if Congress said that CNN Mexico, that CNN Mexico can't get money or assistance of one sort or another from the U.S. unless they don't cover cases in which the U.S. Border Patrol kills a child or something like that? I mean, pure First Amendment like broadcast desire to run that story. They run that story, then they're being punished with respect to their CNN Mexico. I don't think it was an easy case, but in other cases, in Hobby Lobby, for example, they had a very different take when they're talking about corporations, individuals. One person corporation is treated exactly the same as an individual, and I thought some of the better briefs there argued if you want to take the corporate form, you may have to get less protection, or at least a different sort of protection. The contrary, of course, to Citizens United in that area. I wanted to, before we do the questions, just wanted to take you to the Little Sisters case, which you argued and won in the last term of the court. To what extent do you think the First Amendment protection of religious freedom had an impact on the victory, even though that was not what they talked about in their ruling?
Yeah, so Floyd, it's a great question. I do think it played a pretty big role in the background. If you look at the metes and bounds of the opinion, and then you particularly kind of recognize that ultimately on the disposition there were 7 justices that agreed with the disposition of the particular claims in the case. it doesn't seem like a First Amendment free exercise case because they ultimately decide the case on the ground that there is sufficient statutory flexibility in the Affordable Care Act to kind of make exceptions both for religious objectors and moral objectors. And so, the breadth of the exceptions, at least as, arguing that they aren't permitted by the statute, that argument sort of wasn't successful. And then most of the APA arguments that were actually before the court didn't go to the breadth of the exemptions, but went to kind of the procedural challenge to the way they were promulgated. And so Justice Thomas was able to write an opinion for the court that could get in and out of that without saying too much about the free exercise or even RFRA. But he did allude to it in a section of the opinion, and I do think it sort of provides, obviously the background for what the government was doing, but I think probably sort of, explains the decision in large measure. And where I think that, I think the hard issues, and you see this a little bit in the Espinoza case. I don't want to get too far afield, but you see this in the Espinoza case. The hard cases, I think, are, when does the government sort of have to do something to accommodate a religious objector? And I think, particularly for the conservatives, I think, their way of looking at this case is, look, when the government, put aside what the government has to do, when the government is trying to do something to accommodate the religious objectors, we got to give them a little bit of slack. There's got to be some play in the joints for that, to use a controversial term that, used to be in the cases in a slightly different context. But I think that's where kind of the five justices were in sort of thinking about the case, that they certainly weren't going to look at this through the lens of the Affordable Care Act and the APA in a way that gave the government sort of kind of only one channel to get through in this case. And I think that kind of explains why, maybe the majority of the court didn't talk more about the religion case, the religion issue in the case, because, on behalf of the Little Sisters, I essentially argued that the government had to accommodate the Little Sisters. And I think in a case where the court could save that issue for another day and say, well, at a minimum, the government can, certainly as an ACA and APA matter, but probably I think the majority opinion suggests as a matter of kind of RFRA and constitutional law. I think that's kind of why they sort of backed down. And of course, Justices Breyer and Justice Kagan wrote separately to sort of, suggest the possibility of a different APA challenge in the case. But what I think is interesting is the way I read that concurrence. I'm not so sure it suggests that Justices Breyer and Justices Breyer and Kagan necessarily had a problem with exempting the Little Sisters, who had a objection to even the government's accommodation that was in place previously. I think where the concurrence was going is to really focus on the breadth of this exemption and the fact that people were exempted, employers were exempted who didn't even object to the prior accommodation. So I think that's where kind of the concurrence was, and I think it all, to me, reinforces the idea that the First Amendment principles were very much in the background, even though they didn't emerge as as the absolute reason the court decided the case the way it did.
Seth, you want to take it from here?
Sure. So thank you both very much. What we'll do now is open it up for questions. Let me say just a word about how to raise your hand virtually. On the bottom of your screen, if you hover a bit, you'll see a blue circle that has a person looking like they're holding a stack of books. I'm not sure what that's actually supposed to be. If you click on that, you will see a list of participants in a panel. You'll see the panelists listed in a panel usually on the right of your screen. And at the bottom of that panel, there's a button that looks like a hand. And if you click on the hand button, that raises your hand. It will then show up on my screen that you've raised your hand. And then what we'll do is get Lisa to unmute you so you can ask your question and engage. So if there are folks with questions, feel free to do that. I have a question, if I can take a point of personal privilege, just to start us off while we're waiting for people to ask, which is, do you have any thoughts, either of you, about what the court's going to do in the Mckesson case, about the protests?
You're talking about the Fifth Circuit case?
Yeah, for the Fifth Circuit.
Yeah. No, I did a brief on that case. I have to tell you, I feel sufficiently invested in the case. I'd rather have Paul comment if he's up to speed on that particular case. It does raise some really, really interesting issues for those of you in the audience. Black Lives Matter protest at a time when Black Lives Matter was not as popular as it is now. A protest in North Carolina where they essentially stopped traffic by what they were doing by protesting. A level of violence occurred. Someone on the Black Lives Matter side of things, a protester, threw something that hit a policeman and injured him badly in the head. The policeman sued Black Lives Matter and the person in charge from that organization of putting the protest together. And the lower court, I'm saying it, oversimplifying a bit, basically said, look, you were in the midst of a tortious conduct. You were stopping traffic in violation of the law. It was predictable that one of your members might throw something, and in the context of an ongoing criminal conduct, when this happens, the person who put the protest together can be held liable. Well, the burden of the brief that I joined said is that would really eviscerate and certainly impose enormous threats on almost any sort of protest in which feelings run high and the like. I mean, the policeman, of course, could have sued if he knew who the person who threw it, and maybe a different issue, maybe Black Lives Matters, although I would say probably not there also. But holding an individual liable in a situation where what he did wrong was to put the protest together seems to me a pretty far reach. Paul?
Yeah, I mean, Floyd, I haven't followed the case as closely. Where procedurally is it right now?
It was on a motion to dismiss, which was not granted, and I have to interject myself. I'm not sure anymore. There was no trial. I know that.
Okay, but is it before the Fifth Circuit at this point?
The Supreme Court on petition for cert. The Fifth Circuit upheld the liability or the potential for imposing liability.
Yeah, no, that's helpful because I thought it was kind of cert pending. You know, this might be a case, frankly, where the court might use its shadow docket because, you know, on the one hand, it seems like a problematic result, and I think the court will, you know, have some sympathy that that's not a result that really the First Amendment should tolerate. But, you know, I just wonder whether they want to have that case on their docket and argument and all that would come with that. I mean, that just seems like that, you know, a case where you know, a cautious John Roberts might think that the right way to deal with that is a per curiam opinion that, you know, provides some relief but doesn't necessarily put kind of all of those issues, which are obviously, you know, they're going to be looked at in a completely different lens from the time when they happened. And, you know, you just wonder whether John Roberts would want that case on the merits docket. It's an interesting conundrum. I do think he'd be sympathetic but I also think you might be a little worried about kind of everything that came with that. It's a little like, they had these qualified immunity cases that got a lot of attention and a lot of interest, and there was some, some interest that maybe the court would take that, in the wake of everything that's happened, and then the court ended up, kind of, not taking him, and Justice Thomas just wrote a dissent. So I do think the court gets a little leery sometimes about kind of taking, a case at a time when the public attention is going to be that focused on the court. But we'll see. It's a fascinating case.
Yeah. Seth?
So let me go now, at least if we could, to Frederick Lane, and if you can bring him up, but go ahead. Are you there? Frederick Lane. I'm not sure what happened there. We'll see if we can get him back. But in the meantime, why don't we go to Francesca Procaccini, one of Floyd's colleagues and I think co-teacher from Yale Law School, if I have that right.
Yes. Hi. You can hear me. I'm on mute, right? Yes. Okay. Wonderful. So yes, and I'm going to apologize to Floyd because the question I'm going to ask is one that we have talked about personally, but I'm curious to get both of your opinions, and Paul, you as well. You mentioned the court's, especially Justice Roberts' desire to chip away at precedents that he doesn't find persuasive, rather than doing full-scale overturning, and that actually relates to the point you just made about not really wanting to put the court front and center on some of these hot button issues. One thing Floyd and I have been discussing that I would love your opinion on is the role, if you feel there is any difference to the role that stare decisis plays in the First Amendment context specifically. Obviously, this chipping away tactic is one that is being widely discussed in other areas of the court's jurisprudence. You mentioned Abood and Janus, but obviously abortion and those, Planned Parenthood, those cases are bringing up the same conversation. Do you feel that the court looks at precedent and looks at stare decisis in a different way when it comes to First Amendment rights, or is it sort of just par for the course?
I mean, I'm happy to start, or Floyd, if you want to, whichever you prefer.
No, why don't you, Paul?
Sure. I mean, so I think what I would say is I'd sort of give you a qualified yes. I think they do look at stare decisis differently in, the First Amendment context. And, look, if you look at the sum total of everything the court has ever said about stare decisis, I think it boils down to it depends. And, one of the things it depends on is sort of the context and the constitutional right at issue. And, and I do think that, in the context of the First Amendment, particularly if you have a, pretty pro-First Amendment court, it would be a little bit surprising if, the court wasn't sort of, more willing to overrule a adverse First Amendment precedent than maybe sort of some other precedent on the books. And so, it seems to me that, when you have, seemingly a broader agreement of the justices in the free speech realm, just directionally, maybe not methodologically, but directionally, that in other contexts, it does seem to me that it would be understandable that the court would be more willing to overrule the precedents that get in the way of where the court's going sort of directionally in that area. And then I think that's probably reinforced by the idea that, I think the Roberts court, sort of feel like, kind of vindicating, and the First Amendment is really kind of at the core of what the justices and the Supreme Court are supposed to do. There are other areas where, there's less, I think, of a consensus about exactly what the court's doing. Whereas I think as a general matter, the 9 justices feel like, they're supposed to be protective of speech, and, and sure, they may get criticized for those decisions, but, the First Amendment free speech clause is a, sort of counter-majoritarian protection, so don't be surprised if there's criticism when they've indicated. So all of that seems to me to make it, like, I don't think they're going to ever say we're applying a different test in the First Amendment in stare decisis, but I think the context is going to make them a little bit more willing to revisit some of their precedents. And I guess what I'd say is, it seems to me the proof's in the pudding. I mean, lots of people are concerned about stare decisis, concerned about chipping away in other contexts, but some of the clearest examples where it's kind of already happened, that you not only have the chipping away, but then you have it culminating in the overruling of a precedent despite stare decisis, you have had a couple of very clear examples of that in the First Amendment context, all in the direction of being more protective of free speech. So to me, I think whether you look at it kind of, from first principles, or you look at it just in terms of, where the court has used the methodology of chipping away all the way to overruling, I think they both suggest that there is something different going on in the free speech context.
Just to emphasize one phrase in your very last sentence, I think they do it almost invariably when they're expanding First Amendment rights. I can't think of there may be some cases, but I can't think offhand of cases in which they refused or chose not to follow a prior First Amendment protective ruling of theirs by saying, at the end of the day, we went too far in protecting the First Amendment and there ought to be less protection.
Francesca, did that?
Oh, absolutely. That was great. Thank you both.
All right. Let us try to go back to Frederick Lane one more time and see if we can get this working.
Okay, folks, can you hear me now?
We can. Perfect.
Fantastic. Thank you. Gentlemen, this has been absolutely fascinating. I think this has been a really interesting session of the court, and I think we're only going to get more interesting as they go forward. Here's the relatively straightforward question. I'm working on a book called The Rise of the Digital Mob, which is about the impact of digital technology on speech, on society, how we interact with each other. And my question for you is, what do you think the limits are in First Amendment terms of the ability of Congress to regulate speech platforms? Now, they may have multiple reasons for doing so, but will the court perceive these to be a threat to speech? If, for instance, Congress tries to break up Facebook or tries to extend, for instance, hate speech to those platforms. And we've obviously seen some interesting controversies just in terms of labeling for truth or accuracy of political advertising. So I'm just interested in hearing your thoughts on what the potential parameters are. Obviously, I understand that specific facts matter, but we do have some general concepts here to work with.
My reaction is that Facebook and its competitors will have and will continue to have a level of First Amendment protection which is extremely broad and probably no less broad than the historic press and the like have received. Now, that doesn't mean that Section 230 of the Communications Decency Act can't be repealed. It doesn't mean that any of the many different decisions made by different social media entities will not be different from each other or criticized by politicians and the like. But I just don't see the court accepting as consistent with the First Amendment anything which deals with content. Sure, antitrust laws and the like are something else, but anything that is aimed at or put aside the intention that so directly affects content, I think is going to be held protected.
Let me just follow up with one real quick question. Then for you, sir, the specific question is, what are the limits, if any, of the First Amendment on active disinformation?
I don't know the words you're using. Well, what is active disinformation?
Yeah, and that's obviously a loaded term, but and again, we're dealing with private companies, so it's a slightly tricky thing. But I guess really the fundamental question is, does the First Amendment categorically protect falsehood?
We have a lot of laws, but if the falsehoods are political falsehoods, I think the First Amendment goes just about all the way towards protecting that.
Interesting. Okay, thank you.
Paul, did you want to add anything before we?
No, I mean, I'm currently representing Facebook in the Supreme Court, so I think, the more Floyd says, the better, and the less I say, the better.
That's a matter of perspective, but okay, I take your point.
I do appreciate the feedback. Thank you.
Ron, you had a question you wanted to ask, I think.
I like the way you dodged that, Paul. We should have asked you a question about Twitter, but that's another. I was very much intrigued by your comments about the relationship between severability and the First Amendment, and how we might think about fashioning new rules or a new approach. Can you just elaborate a little bit about why you think severability operates differently than in the First Amendment context than, say, in the equal protection context? And what would be the kind of case, the best kind of case you think to bring up to get the court to reconsider the relationship between severability and First Amendment protections?
Yeah, so let me say that just in terms of the elaboration, I think the argument really, and this, it starts to get a little theoretical, and I would, defer to, Floyd and you and others who think about the First Amendment for a living, as opposed to me who just, sort of dabbles in it from time to time. But my way of thinking about it is, in the equal protection context, I mean, you're protecting equal treatment for the sake of protecting equal treatment, which is to say, the whole point of the clause is to prevent the government from discriminating. So it makes a certain amount of sense that when you get to the point of remedy, and the constitutional problem is the unequal treatment itself, that the way that you remedy the unequal treatment could be to level up or level down. It seems to me that we get so in the First Amendment with all the doctrine, you get so focused on, well, the First Amendment problem is viewpoint discrimination or content-based discrimination. There's a tendency to think of the First Amendment as being kind of an anti-discrimination protection akin to the Equal Protection Clause. And I suppose if that's the right way to think about it, then it's fair to say, yeah, level up, level down, who cares? But, and I don't mean who cares, I just mean, what's the difference? It's an anti-discrimination principle. But I don't think that's right. I mean, I think the reason we care about discrimination in the First Amendment context is not as an end in itself, but as a flag that the government is abridging speech in an impermissible way. And if you sort of think about the First Amendment protection in that way, it really becomes a non sequitur to say, you're right, this is content discriminatory, and the way we're going to get rid of the content discrimination is to effectively create a remedy that abridges more speech than Congress itself wanted to abridge. I mean, so if you go back to the nub of what the First Amendment protects, it says, Congress, shall pass no law abridging speech. So if you show that Congress has impermissibly abridged speech by, say, favoring its favored speaker by creating an exemption, it doesn't seem to me to fully remedy the First Amendment problem to say, oh, you're right, you caught him, let's abridge some more speech. I think the right response from a First Amendment perspective is no. That's the last thing we want. We're here to prevent Congress from abridging speech. So if they abridge speech in a way that's impermissibly discriminatory, it's not enough to get rid of the discrimination. You should err on the side of essentially having Congress abridge less speech. And hey, frankly, if they want to go back and they want to, try to fine tune it again, or have a different non-discriminatory content viewpoint way of kind of coming at it, that's fine. We can evaluate that, but it shouldn't be the court's role in remedying a First Amendment problem to abridge even more speech than Congress. That's sort of the nub of the argument, and why I think the First Amendment free speech clause is meaningfully different from the Equal Protection Clause. I just think that this. So I'd say two things. One is I think the court typically kind of acknowledges this without even thinking about it, because in most of the content-based cases, you think about Reed v. Town of Gilbert, or Gilbert v. Town of Reed, whatever it was. In a case like that where they say the restrictions, it's content-based because some signs get up and some signs go down. The court doesn't say so no signs. That would be kind of an absurd result from a First Amendment perspective to say that's right. They're discriminating on the basis of content, so nobody gets to say anything. So I think it's maybe more just kind of part of it maybe just kind of pointing out in the next case how aberrational this case was, and then the second thing would just be I do think this was kind of the perfect storm, because as I said, if you don't think about it from these first principles and you just think about it like the problem's the exception. Severability says, what would Congress want? We know what Congress wanted because it was perfectly happy to have the prohibition without the exception for 25 years. Like, that's a formula for losing. And I think that, the hope was to get the court to sort of say, no, that's wrong. I almost think we lost them at step one. I mean, step one is, what is unconstitutional here? It's, and there's this kind of soft way of thinking that what was unconstitutional was the content discriminatory exception. And I think if instead you say, no, it's the content discriminatory exception that made the prohibition discriminatory or violative of the First Amendment, then I think it becomes easier to say, okay, the prohibition is the problem, and we certainly can't sort of make the prohibition broader than Congress did. So anyways, that's I hope that's responsive. I mean, I think that basically, this argument I think is more intuitively powerful than because I think it just shows it's what the court does almost without thinking in other cases. And so I think that the hope will be to just get a better fact pattern and then kind of get them to understand that this case was a bit aberrational, either because the exemptions came so late, or because, as Floyd suggests, the court really doesn't like robocalls.
Well, thank you very much. Why don't we go, if we could, to Casey Maddox, who has a question.
Thank you. And I have actually seen them, and there have been cases where people have brought challenges on license plates, for example, and seeking only to invalidate plates that have been approved. And because their plate was denied, I've been involved in those cases before, so maybe there will be opportunities for the court to clarify that. But I just wanted to quickly ask about the Uza Bunham case. The court granted at the very end of the term, and that's a case out of the 11th Circuit that basically raises the question whether nominal damages are sufficient to prevent mootness in a First Amendment case, where the 11th Circuit has said that they're insufficient and broke with other circuits. I was, full disclosure, was initially involved in that case, but I'm curious as to what you all think about what the court may be looking to do there.
I'll weigh in first, but I don't know the case, so I speak with special authority. I think it'd be a very hard sell to say that a case is moot, because what is left in it, or the most the plaintiff can get is nominal damages? I mean, the purpose of libel law, after all, is to restore wrongly lost reputation. And a victory in a libel case by a plaintiff does that, even if the damages are slight.
Yeah, and I mean, I spent a good chunk of this last term trying to convince the court that a case wasn't moot, and wasn't ultimately successful. So I think there will be some sympathy for the argument. I think that Floyd has kind of articulated in a way that frankly I think would be helpful, because I think maybe getting the court to understand. I mean, if nominal damages are viewed as kind of as the functional equivalent of nothing, then the court's its instinct is going to be to say that the case is in fact moot. If you understand that nominal damages are either still damages, or, as kind of Floyd suggests, they can be a stand-in for something that kind of. I mean, the way I hear Floyd articulating it, is that maybe in the First Amendment context in particular, nominal damages was kind of like the common law's way of sort of creating a declaratory judgment that sort of vindicated somebody's reputation. If you kind of pitch it in those terms, that seems like a much more attractive argument. That that's real, and the case is definitely not moot.
Thank you. And I've now gotten myself unmuted. It's now 7 o'clock, so we want to thank you both very much. If you want to say any last remarks, happy to have you do that, and then we'll wrap up.
I just say, I want to thank you for having me. It's been a pleasure, but it's been a particular pleasure to be on with Floyd. Like anybody who, thinks highly of the First Amendment and constitutional law, Floyd's a hero. So I'm privileged to get to do this with him. So thanks for the opportunity.
Well, then it is not simply being, polite to say that it's really an honor for me to be on this two-person panel with Paul Clement, who's argued 103 cases, and don't correct me on this, probably 190 of them. So thank you, Paul, for coming.
No, my pleasure.
Well, with that, we will wrap up. Thank you both very much again. We really appreciate it. And I'll join on behalf of everybody who's not able to clap audibly. We will clap for both of you, and thank you again for doing this. Have a good night, everyone. Thank you.